And as you sit here right now, you are clearly more biased towards the defendant in this case than you are towards the state, correct?
I am just here I don't have any, I love my son, of course, but I'm not going to jeopardize anything to cover for him or anything like that, if that's what you're saying.
Okay, now, as proof of that, you did send a text to your mother referring to the Grunwalds saying, "Fuck them old ass idiots who know nothing about."
Whoa, objection.
This goes to bias.
Objection.
Yeah, this goes to her bias, Judge. Yeah, really, she's lying now, Judge. And this shows why she lied.
I'm gonna go ahead and today, go back on Wednesday morning at 9 o'clock. Be here about
Wednesday morning?
Wednesday morning, yeah, we're not doing trial tomorrow. We wouldn't finish with this witness anyway, because we're still gonna be prosecuting.
It's her text to her mother. Again, December 11th, when we had this flow of information.
After all
about-
the stuff about the
But-
video and the clothes and the hoodie and everything
Right.
else, what does she say?
So basically, she says, F the parents and F the dead kid. That's basically her statement here in black and white. Now, the state, so right now, we have this witness, Judge, who says one thing on the stand. She's already changed her mind on getting rid of the clothes that possibly could have been for evidence destruction. On the other one, we have a number of texts that are contradictory to her statement.
Which you have established already.
Right.
You've gone through all those.
Right, and then, this is the motive for her lying. Clearly, there is still a connection between her and her son, and it is so strong that she could maybe say that she was drunk or high, I don't know what she's gonna say, but her connection to her son is so strong. Not only is she getting rid of evidence of bloody clothes, and she says that she saw blood on him in the text.
She's already admitted to the jury
Right.
that might have been the case.
Right. The
Why
bottom line
do
is
we need this? Why do we need that?
this is the ultimate evidence of her bias. If she says F the dead kid and F the parents, that is the ultimate sign of her bias. She will do anything for this guy simply because he's got her DNA in him. But this is the ultimate issue as far as why is she telling all these lies to the jury? Because she doesn't give a care about David Grunwald or his parents. All she wants to do is get rid of the evidence and make sure that her son doesn't go to prison. It's obvious from these statements. It's clear from these emails that she was collaborating with Samuel LaRue to destroy
And I will
evidence.
agree with you.
Right.
But you got to impeach her, and you
Right.
established that to the jury, so why do I need that? Why should I let that inflammatory statement come in?
Because why does the court say you can have the evidence that's mediocre evidence of her bias, but you can't have the ultimate evidence of her bias? She comes here, she's not a caring witness, Judge, that's gonna tell this jury the truth about this case. She comes here as evidence, the court can read the rest of the text. I just picked like the greatest hits of Ms. Johnson. I have a copy for the court. This whole thing shows that all throughout the investigation, she is on top of it with her mother. They're talking about destroying
Okay,
evidence.
well, why didn't you ask her, what is her opinion of the Grunwalds? And then if she says that, she denies it, then you can impeach her with that. I mean, you didn't even really give her a chance to establish that. Well, it might go to bias if she thinks it was, that she was covering for her son.
I think your honor should read the statement first.
It's worse. I know, I didn't even get to the good parts yet.
Well, if that's what he calls the good part, I would feel tragic for him. One, it's inadmissible, this is inadmissible, because what they're trying to do is characterize my client with his mother's statements, and it's really a way, it's 403. There's no way it passes a 403 test. And quite frankly, just because something is biased, it doesn't mean it necessarily passes for.
Judge,
And I let him speak, I get to speak, I'm gonna ask for a mistrial. This is mistrial stuff, I mean, it was so bush league. He should have, first of all, he should have approached, to your honor first before bringing that statement out. That came kinda out of left field, and that's mistrial law. I think you need to look at the statement, and it's a complete mistrial, it doesn't pass.
Well, bring me up to statement.
yeah, let me respond, Judge. What is tragic is that this witness cares more about her son than a murdered boy and giving the truth in a jury trial. That's what's tragic here. And the defense has all
And then
this.
they called somebody.
Judge, he has it in his binder.
I have it, I'm not saying I
Right,
don't have it.
so these things, if you're looking at this
It
and.
doesn't mean it's admissible.
Well, right, but if it was so prejudicial, you know, we had motions about everything in this case. Why not have a motion to eliminate? If they really are
See, I
scared
thought
of this.
I thought an experienced district attorney would know what the.
Yeah, an
rules
experienced
were.
district attorney knows that this goes exactly
This
to
does
her
not go
bias.
to bias.
When
This
she
is-
says F the dead kid and F the parents,
This is-
that goes
this
to
is-
bias.
Don't say anything. This is.
Oh, well, now he's representing the witness too, yeah.
Well, she's a witness and she shouldn't be talking, this doesn't concern
No,
her.
she shouldn't be. Okay, here's the
And so,
situation.
asking somebody to do something proper, I guess, is no longer, this is, look, her statements are her statements. It doesn't mean they're admissible, in here. And that's, you know.
Here's the finding I'm gonna make, okay? I'm not gonna let you get into that statement, Mr. Kelly.
There needs to be structural damage has been done, that's what's been wrong.
But.
But why, Judge? It shows that she is biased against the
I think you've
victim
already,
and the victim's
It's his
family.
mother.
I
Of course she's
think
biased.
you've already established.
Well, I know I have, but Judge, but why hide this from the jury? Because the F word is used or because she swears
This
at
is
the parent?
inflammatory, it's 403.
Because it makes this witness look really bad, and the defense thinks that they have the need to protect Dominic Johnson's mother. She has a lawyer, he's sitting right there, he's not jumping up and down, it's them that are
It's not
jumping.
his
up and down.
trial. It's
This witness, is the state paying for his?
Look, it's not his trial. I'm objecting to the inadmissible evidence that's trying to be used against my client. It's her statement. She's not on trial.
No.
And,
But
so.
her truthfulness and her bias as a witness in this case, she's a witness that has testimony that is relevant in this case. She's already laid it out.
She
I mean, she was given it, listen to me, she was given immunity because by her own admission, she probably had the intent to destroy evidence in this case. So that's been established, she even admitted it, just 5 minutes ago. And that's why we gave her immunity. So she's gotten immunity, and she's testified to that now. So her bias is at issue in this case, and her truthfulness at trial, and her denial, there's no doubt about that. That's been established, but it can only go so far, Mr. Kalytiak. So I think, what other questions do you have for her?
Well, that was my last inquiry, is those statements, because again, we feel like they are telling statements as to where she's coming from. She will do everything she can, including evidence destruction and lying, to protect her
Why
child.
don't you ask her that question directly when you come back?
But then she's gonna say, no, I won't, and then the court says I can't use these
Well,
statements, but, I mean.
It's pretty obvious, I mean, again, I think you've established it without having her attack the parents. There's something about that I do think under 403 is a little inflammatory, to be honest.
And remember, Judge, we're not the ones that wrote those statements, we're not the
No,
ones that chose those words.
I understand, but there is some sort of inherent connection between the mother and the son. I mean, it's there. And,
Yeah, but a lot of-
and your intent is to impeach her, to show that she's basically a biased witness and that she's covering for her son. That's your intent with all this evidence that you brought in.
Well, I think it's pretty obvious at this point, Judge. I don't
That's
know.
what I'm saying. I
Yeah.
think it is pretty obvious. So I think we'll just leave it at that. If on cross-examination, Mr. Stohler opens some doors, then you can re-petition the court to get into some of that additional information, or additional statements that are inflammatory. It's not even really information. It's her statements of her anger against the Grunwald family and her lack of empathy for the whole situation, protecting her child. That's what those are. And if, I don't know what kind of questions you're gonna ask her, but I would suggest you be very careful, because her bias and her protecting of her son and covering the evidence has become an issue in the case. And that's why she was given immunity. So can I see the rest of those statements?
Yeah, I had a copy.
I have not seen those before. There wasn't any motions in limine or anything like that. So
And Judge,
of course,
I didn't-
reviewed any of these, so.
There's no motion in limine because they're not my client statements, they're.
I know.
Right.
I know.
I mean, but obviously, Judge, this is a witness who.
The time to object to objectionable evidence comes in.
Oh,
Alright,
that's
well,
fine.
that's
I'm
the
pretty sure
way-
the Court of Appeals has said that more than once.
I'd much prefer to do it that way and do the arguments in the open than do it through motion,
But anyway, I'm gonna deny the mistrial, but I'm gonna have you just move on, Mr. Kalytiak, if you don't have